Hello. Uh, let's see if this works again. So we are going to do live a fun session today. I've got my very good friend Swati Desai, who should be joining me here very shortly. So I'm going to give her a moment or two to get connected and get on, and hopefully here she is. So let me see if I can do this. If I remember how. Go live with an app and the magic of there we
Oh,
go.
it
Look at
worked.
that.
Yay.
We are live.
Oh, exciting. This is my first Instagram live. Thank you, Dave, for navigating me through this. This is exciting.
This is exciting. Yeah. So this is my second time, Swati. So please be patient with me because we'll see how it goes. But no, I'm excited that you're here joining me today. So you know, Swati and I have known each other for some time, and we did this once before, a webinar before, and I absolutely love talking with Swati. It's actually one of the easiest things to do because we just, we vibe, we get each other, and so I thought this would be a lot of fun for us to do this today. And so I'm glad this worked out because, like, look at it, we're actually going live.
I'm glad it worked out too. And listening to your cute Irish accent is just icing on the cake. So
Well, yeah, I mean, if after 22 years of marriage, my wife is now starting to tell me she wish I had a Scottish accent. And I'm like, well, you know what? You had your chance, right? You were over there. There were Scots, there were Irish, there were English people. You didn't want an English person, but you got the Irishman, you're stuck with it. So, yeah, I think it wears on. But so what I'm going to do is I'm just going to introduce myself and explain a little bit about who I am and what I do. And then I want Swati, she's going to introduce herself and explain about, because a lot of what we're going to be talking about today, the subject for today is about evidence, specifically evidence when thinking about going to court. I'm a mediator. Swati's a family law attorney with amazing background and experience. And so we're going to talk about that making that transition and why one option might be better than another, and thinking about the pitfalls of going ahead. So as I said, my name is David Dowling. I am a mediator here with the California Family Mediation Center and partnered with the San Diego Family Mediation Center with Jen and Amanda. And my background is that I was a law school professor for many years, transitioned then into practice, and I still teach part-time at Pepperdine, and I love mediation, and I truly believe that it is such a great option. One of the great benefits of doing the work that I do is I get to partner with folks like Swati, because I have clients that need some great advice. I have people that come into me and I say, look, mediation might not be the best option for you, so let's send you over to Swati and her team so that they can assist you. And so I think it's great to have that rapport and relationship with somebody in that world. So Swati, why don't you introduce yourself and explain a little bit about your background and what you do?
So my name is Swati Desai. I have a boutique firm in Orange County, Desai Family Law Group. We're very hands-on, and we take a lot of pride in our work. We're exclusively referral-based, and we don't do any advertising or marketing. And we really, really try hard to give our clients the level of service that they need, because this is a very difficult and an emotional time. I started practicing about 20 years ago. And when I first started practicing, I was doing business litigation. I really struggled with going home every day and thinking I made a difference. I felt that my work was really not something I could sustain doing long term. And I started dabbling in some family law work. And one thing led to another, and here I am today, almost 20 years later, doing the same thing that I started doing and I still love to do. So I became a certified family law specialist about over 5 years ago. And so when you become certified in a specific field of law, you're basically committing yourself to that specialty, because there's a lot of work involved to become specialized, and there's an extra exam and whatnot to take. So if you're looking for a family law attorney, it's always helpful to find someone who is certified, because it's almost like a stamp of approval that they know what they're talking about.
Right. I think, that's one thing that can make a big difference is, people assume that once you practice law, everybody's the same. And there are, some significant differences, as you just pointed out. The fact that you're certified means that this is a focus and an emphasis that you've specialized in. You've done additional training to provide the best service for your clients. And that makes a difference, because a lot of times we think, and what's amazing is that, going the attorney route can be expensive, but making sure you find the right person who can do the job makes all the difference when you're paying those kinds of fees.
Correct. And like you, Dave, I know you've done all this extra training and certification to be a mediator.
Yeah.
And I know the quality of work that you provide. You have settled cases that I never imagined could ever be settled. And that really is very telling of the skill set that you possess, which, is why you're so good at what you do. So I think going that extra mile and making sure you find someone that has that backing is definitely encouraged for anyone looking for either mediation route or litigation route.
Yeah, I appreciate that. Swati and I, when we get talking, as I said already, we really enjoy working with each other. So it's very easy, and it makes a difference when you have a relationship with somebody that you highly respect in their field, and you also believe is just a good person. When I'm recommending clients, whether it's to a realtor, a therapist, financial advisor, or to an attorney, what I want them to do is come back and say to me, "Thank you." Like, that made a big difference. Like, working with this person, because they're an extension of how I view myself in my practice, right? And so recommending it makes all the difference. Swati and I were just swapping cases this morning, talking about some experiences, and it's kind of fun when we get started. So I did want to kind of get into this idea of, because one of the things we wanted to talk about today is evidence. And I think it's interesting, because when you don't come from a legal world, you don't come from a legal perspective, when people go to court, especially when they represent themselves, their understanding of what evidence is and what a court will accept and what it should look like. I don't think they even really understand that there are different standards of evidence depending on what you're doing or how you're doing it. And that can be a challenge that a lot of people face when they go through this process. Do you want to touch on that a little bit and explain, your feelings and thoughts on that?
Absolutely. So anytime you're in front of a judge, you have to remember they're human, and their life experiences come into play when they're making a decision on whether or not you should be awarded custody, whether you should be awarded this community interest in an asset or a separate property reimbursement claim, whatever it is that you're seeking from the court. It's imperative that you do your due diligence and you come up with exactly what evidence you want to present. And sometimes clients come to us and they say, well, what do you mean by evidence? I say, well, every single text message that you send to the other parent or your spouse is a court exhibit. Mm-hmm. And make sure you don't use profanity. Make sure you are very careful in your word choices. No all caps, no exclamation marks, because that sounds like you're yelling at the other parent. You have to be really careful, because a judge could review these messages one day and consider them in determining whether they think you're cooperative or not. If you think the other parent has a drinking problem, you're going to have to prove to the court that they're a habitual user of alcohol or drugs, and therefore the court needs to order random drug testing. Well, how do you do that when the other side could potentially deny that they're a habitual user? Well, do you have photos of them passed out on the couch? Do you have photos of the trash with all the empty bottles? Do you have credit card statements that show that, the other party is purchasing alcohol from the local liquor store or the gas station or the grocery store receipts or whatever it is? But it's up to you to be your own PI, mm-hmm. and fight for your own case and gather evidence early, because it's so hard when you're not living under the same roof as the other party to gather that evidence that you could have gathered during the marriage or the relationship. And if you're going to go to court and you're going to tell the judge, yeah, he was using all throughout the marriage. He was using marijuana every day. Okay. And the other party's going to say, no, I didn't. I only did it once in a while when our friends would come over, or we'd hang out. I didn't do it all the time. And now it's a proof problem. So, you know, it just helps if you have that evidence, or even text messages where you say, I'm not leaving the kids home alone with you because I know you're going to use tonight like you do every night. I'm going to take the kids to, you know, one of our parents' house. And if they say, okay, that would be great. Thank you. Well, now they've just admitted that they're using and that you can't leave the kids home alone. Something so simple like that would be very helpful evidence to present to a court.
Right. I mean, it's unfortunate because a lot of people don't think about gathering evidence, right? When they're considering a divorce, when they're married to somebody that's either an abusive situation or the person's abusing substances, they're more concerned about the children and themselves, their finances. You know, I've done cases with, and, you know, really unfortunate situations. I had one couple that I worked with, and they love each other. They truly do love each other, but he abused alcohol to such an extent that it harmed their finances. It harmed, you know, put their kids in danger and things like that. And she had to kind of walk away from the marriage. So through that process, her concern is, how do I deal with this? How do I end this marriage? How do I find a way to move on for myself and my kids? And we never sit there and think, I should collect evidence, right? I should be gathering this information. But you said it succinctly, is that you go in front of the judge, and what it comes down to then for the judge is it's a he said, she said, right? You know, one gets up and says, this is happening, and the other one's like, that never happened, right? And it's frustrating because I've dealt enough times with this where somebody's like, they're lying, right? They're not telling the truth. That's not how it happened. They're lying about the situation. But really, the judge on the bench, she or he has to make this determination based on gut feeling or instinct when it comes down to a he said, she said. And right, they don't want to deny somebody access to their kids based on the fact that one person's laying allegations that they don't have support for.
Agreed. And, you know, on the flip side, if you're the user and you've come clean and you've gone to rehab, or you've just stopped on your own, and you know that the other side is going to use that against you and you're concerned about that, be vigilant. Go and get tested once every few weeks at a lab and keep those results. Because if you end up having to go down a custody route, at least you can tell the court, no, I knew this was going to come up. And in abundance of caution, I went and got these tests done on my own. And that way you can at least have something in your back pocket ready to go in the event you need to.
Right. So you bring up testing, and this is a good issue because this is something that comes in mediation, right? I have clients that come in and say, look, my ex, I believe, is an alcoholic or using, right? And so they want to set up something because they don't want to deny them the opportunity to see the children, to spend time with the children. But we know that as parents, both of us are parents, right? Our children's safety comes first. And, you know, there's no way to avoid realizing that if somebody's an abuser of alcohol, they don't think about getting in the car when they've been drinking and what can happen to them. And then they don't take the extra step to think about, oh, now my children are with me. They just live their life, right? So what are some things that you know that people can do or request that you recommend that they think about using or requesting as part of monitoring?
So that's, it's really amazing to see what technology, for lack of a better word, has come out to help parents find a solution that gives them comfort. So let's take, for example, you've got, you're married to someone, they're an alcoholic, and you know, you want them to breathe into a breathalyzer prior to at the start of any visit. You know, one, you have the problem of them breathing into the breathalyzer, and then is that in front of the child? Because you have to see them do it. But now you have technology where it's a digital breathalyzer, and there's a company that's very reputable called SoberLink. And SoberLink sells a subscription to a digital breathalyzer. And yes, it costs, a few $100s a month, but it's peace of mind. It keeps both parents, it's a good compromise because it keeps the parent who was abusing alcohol in check. And it gives the other parent peace of mind that I'm dropping my child off, and I'm dropping the child off to a parent who's already breathed into a breathalyzer before the exchange. And because they've gotten the results on their cell phone, and it's amazing. And it's got facial recognition, so it's not like anyone can breathe into it. It has to be, it's got that recognition. And you can have provisions in your court order that detailed with what level of frequency they need to breathe into it, depending on how bad their addiction was. So you can do every 3 hours, every 6 hours, every 12 hours, depending on the circumstances of your case. Have I had instances where people violate the terms of their sober link? Yes. And what happens? Guess what? The other parent's showing up, and they're going to pick up their kid, and that visit is over. Yeah. You can even have some self-executing provisions in the court order that state that all visits would terminate in the event there was a dirty test, period. Like it would be like you have to go back to court for more orders. So, it really just, it alleviates the need to have a private investigator or asking the child after the visit, hey, did you smell anything? Or did you see an empty cup? Or did you see any beer bottles? Because that's what was happening before we had these resources. And it keeps the kids out of the conflict.
Right. Now, I think we should be clear about something here, right? When we're talking about testing every couple of hours, we're talking about only when the kids are present or before the kids are picked up. What somebody does, because, in mediation, and I'm sure you have this with clients all the time too, they almost want to monitor the other person's entire life. Well, that's not something that the court will allow and even do. If somebody's home alone and they choose to have a drink, that's on them, what they're doing. But what we're doing is we're talking about before the children come and while the children are visiting. After the children are returned to the parent, then they can get up to whatever they want.
Correct. Right. It would be unfair to not allow the other parent to do what they wanted with that when they don't have the kids. Right.
We all know, right? Because this is family law and it's very tough. People see that destructive behaviors have contributed or been the factor that ended the marriage. And they know that these destructive behaviors are harmful to everybody. But you can't use visiting the kids as a means or way to then say, you need to be sober for the rest of your life. That's got to be on the other parent, right? And we're not talking about bringing in evidence that says, look, see, they drink all through the weekend. They're a terrible person. Okay, did they have the kids? No, they didn't. Then the court, it's not going to have the same impact, right?
And then when you ask these clients, well, how did you find out? Oh, social media.
Yeah.
And that's dangerous. That's one question that we do ask all of our clients when they retain us is, do you have, when there's a custody case, do you have a social media account? Most of them do. And we tell them that, the how-tos, what you should do, what you shouldn't do, what you should post, what you shouldn't post. They said, well, my account's private. It's just my friends. I said, no, you'd be surprised. I have seen too much, and all of a sudden your best friend is no longer your friend, is your ex's best friend, or is dating your ex's best friend. And now they've got all this, video footage and all this, picture footage about, and it's a recipe for disaster. And I get that people they crave that social media fix.
Right.
And they want to share with their family and friends what they're doing with their kids or what they're doing with other people. And that's fine. Just make sure if your friends and family are doing something that you think could be used against you, just don't post it. Take a picture, fine. Keep it in your phone. Don't post the picture. And if they insist on posting that photo, tell them you can't be in the photo.
Right.
End of story.
Yeah. I think one of the things that a lot of people don't understand about how harmful social media can be is we use it as a source for expressing our frustrations, right? So when somebody does something, if an ex is in a new relationship, we go on and we vent all of our feelings on social media. Well, they can then take these and say, look, I feel threatened because they said these terrible things about me, or in a very roundabout way about me on social media, and I feel in fear of what they're going to do because they've been posting some pretty awful things, right? And so we don't understand how our comments and our frustrations can be turned against us and used as evidence in support of perhaps a restraining order.
Yes. Restraining orders. Oh, that's such a loaded topic. You know, restraining orders, people oftentimes think, oh, violence.
Yeah.
Oh, he hit me. Oh, he threatened to hit me. And those are the only basis for a restraining order. But, you know, that's not true. They're usually the most common.
Mm-hmm.
And, you know, I always tell clients, well, if he was abusing you, you know, do you have photos? Do you have, did you ever call the police? Did you ever tell anyone? You know, it's sad. People usually don't take pictures, and they usually don't tell people, and they usually don't tell the police because they're embarrassed.
Right.
And they want to stay in the marriage.
Right.
So even if their spouse was arrested, oftentimes they don't want to testify against their spouse because they've now reconciled. And so then they sign a declaration saying that it didn't happen. It didn't happen to the degree that it was reported, or they don't plan to testify against their spouse and they're going to reconcile. So again, all of that can come into play. I have actually one going on right now with a similar situation. So, you know, it's important with a domestic violence situation, find at least one. At least we can bring that one person into court as a witness, as someone who can say that you did share that information with them.
Right. You know, it's funny, as we're talking, I'm thinking about right now, there's a big story in the news about the whole case with Johnny Depp, right? But of course, his ex-wife had photos. So whenever there was an interaction between the two of them, she would go to a friend and they would photograph any marks or any bruises. But overwhelmingly, we don't do that, right? We don't think, we're traumatized by the experience, we're traumatized by the event, and we're in a very emotional place. And it's hard to then kind of step back and think about, okay, I need to document. Again, it's coming back to that idea of evidence, right? Because that's what the court needs. Sorry, my nose is itchy. I had a little bit of skin cancer removed from the side of my nose, and so it's still healing. And no, it's good. It's good. I tell people I'm on my third nose job. I'm looking to be, you know, very narrowed down, get rid of the Irish nose. But anyway, sorry. And it's just, I itch it. And when I'm meeting with clients, I'm like, I don't, there's nothing wrong with me. It's just healing. But to my point, we are in a place of trauma. We don't think about gathering evidence. And that's a problem then that we face, because when people come to you, right? So when they come in here to mediation, we're not looking at evidence. We're not sitting there thinking, because we're working towards a resolution that both parties want to work on. When they opt to litigate, it puts them into a very different circumstance, and restraining orders are very tough. But you bring up a really good, important point, which is, you know, restraining orders are not just about violence or a threat of violence. There's a pattern of behavior that can go towards that. So texts, so a stream of text messages, or as I said, posting certain things that can be interpreted as threats through social media. Somebody can collect that information, and that can be supportive of a restraining order, correct?
Correct. You know, if you have, you know, going back to the abuse and the photos, how you were talking about Johnny Depp.
Yeah.
So, you know, what I have seen people do is sometimes they'll come in and they have photos, but the photo is of their arm, but it doesn't include their face.
Right.
So the problem with that is, how do I know that's your arm and not your neighbor's arm? And so I tell people, if you're gonna take photos, take it of your injury, but make sure you take another one further back, a selfie or something, which includes your face, so we know it's you.
Right.
So I just wanted to make sure I made a note of that. So going to non-abuse type of domestic violence conduct, there's so many, and there's so many people who just don't know that they can get a restraining order for just harassing behavior. If you've got someone who's in a marriage and the spouse tells them, well, if you divorce me or if you leave me, I'm going to show them all the nude pictures of you.
Right.
You can get a restraining order to block that. You can get, restraining orders if someone's going to go, if you think they're going to go live, by posting pictures on social media or whatever about you, or even if they're harassing your family and saying things about you, you can go in and get a restraining order for that type of harassing conduct. But you have to realize those are harder to get because it then just becomes into a he said, she said, and there's no documents to support the fact that usually there's no documents to support that that's going on, because the other side can easily say, I was never planning on posting anything. So you almost have to wait until they do and then get the proof, or wait until they send the messages to family members and friends, have them screenshot it, send it to you to get a harassment order, a domestic violence restraining order based on the grounds of harassment at that time.
Right. So let me ask you, because I did a lot of mediations with civil harassment restraining orders, and the standard of evidence, I know I talked earlier about standards of evidence, is clear and convincing, right? So it goes back to that it's like you said, I'm able to come in and go, here are the text messages, here's whatever, right? The evidence that supports that I feel threatened or that something has been shared, whatever it might be. So for a domestic violence restraining order, is there a difference in the standard of evidence, and what would that be?
Yes, there is. So you can only get a domestic violence restraining order if it falls within very specific categories. You have to have been married with the other party, in a relationship with the other party, have lived with the other party. So there's very specific grounds to get a domestic violence restraining order. If you don't fit within one of those qualifying relationships, then you have to file a civil harassment restraining order. And a domestic violence restraining order is a higher burden because it goes on their record if it's granted. And people don't realize this, but when you do a background check, when you're going through interviews, if they do a background check, it will come up. And I've had situations where we've had to negotiate away the restraining order because you can't cut the hand that feeds the mouth. And as sad as it is, if you're a victim of domestic violence and your spouse is going to lose their job if you get a permanent restraining order against them, you're less inclined to move forward with a permanent restraining order. But there's a solution. What we can do is we can file the restraining order and get a temporary order. And a temporary order gets put in place immediately, and then it gets set for hearing. And before it gets set for hearing, you can work with the other side to just keep the temporary orders in place without having any findings made of domestic violence. And what that does is that protects the perpetrator's record. And even though it comes up, there's no findings made, so it really doesn't have that effect, and eventually it falls off anyways. And sometimes we keep those temporary orders in place for a year even, or longer, because it's a Band-Aid fix. The emotions are running high when divorce is first filed, and then we do just mutual stay away orders in the final agreement.
Right. And I mean, it's interesting because I think, in the restraining orders that I've done over the years as a mediator for the courts, it always surprised me how people don't understand that their name is going to go into a database and it will show up and it will impact their employment. I used to say to people, look, you need to be aware if you want to coach your kid's little league team, if you want to go in and be a parent in the classroom, the school does a background check. If the school does a background check and a restraining order comes up on your record, they have concerns about allowing you into that classroom. So it can impact your ability to parent your child as a parent who might be on the receiving end of getting a restraining order issued. So while you're angry in this situation and you may be doing things that make somebody else feel in fear, think about your behaviors, because you might be putting yourself in a position, as you said, to lose your job, but also it can impact your ability to just parent your kid. To, you know, because a lot of parents after the divorce, they're like, well, you know, I remember doing a case one time and this guy came in, he sat down, he said, I'll do whatever it's necessary because I see my kid, you know, every other weekend, but one night a week I coach his little league team. If the restraining order is on my record, I don't get to spend that time with my kid. So what needs to be done, because I don't want to take that additional time away, because that's something that I love doing and it gives me that opportunity to spend and develop a relationship with my child in that format. And so I think most people don't even understand the long-term ramifications. And I love how you said it, because if the supporting spouse is out of a job, then that affects everybody. And we want people to feel secure. We want them to feel safe. And really it's about figuring out what do, you know, and it's a hard thing to do, right? Is this really a situation that needs to go to the judge and we definitely need a restraining order in place? Or is this that somebody's angry and frustrated and maybe what we can do is work out, as you said, stay away orders, right? And the ability to file another restraining order. And that's something that's important that people need to understand is you can go back and file, if something flares up, you can go back in and request a restraining order. You're not prohibited from doing that.
Correct. And you bring up a good point. When you get a restraining order against the other parent, there's an automatic presumption under the law that that parent should not have custody. Mm-hmm. And it's under Family Code 3044. And that presumption, it's a rebuttable presumption, but it's not the easiest presumption to rebut. And, you know, some people come to me and say, look, I have a restraining order against me. I really want more time with my child. I made a mistake. I shouldn't have done what I did. And I've paid I've really changed. I said, okay, well, what have you done to show the court that you've changed?
Right.
What do you mean? I'm different.
Right.
Okay, well, what is it? What steps have you taken to rehabilitate yourself? And nothing. I've just come to that realization. No, that's not going to work. Right. You're going to have to go to anger management, depending on the level of conflict and the aggression that gave rise to the domestic violence conduct. So you would really need to look at this totality of the circumstances. But I tell them, you've got to tell this judge, I've jumped through all these hoops. I've gone to therapy. I've gone to anger management. I screwed up. And I am committed to being a better parent. Now I've taken these classes. Judge, give me more time with my child.
Right. Right. You know, you bring up, I had a woman come in, I think it was last year, and, you know, we didn't help her. What I mean was we didn't mediate her case. She needed to see an attorney. And, but what had happened was she and the ex-husband had gotten into an argument before they'd separated. They'd gotten into an argument. It'd gotten heated. According to her, he kind of shoved her and she grabbed him as she was kind of falling back and scratched his arm or whatever, lashed out and grabbed his arm. And he called the police. When the police came in and talked to her, you know, she said, yeah, of course I scratched him. You know, I was falling back or whatever and I scratched him. And he denied any kind of shoving. So now she's on the record of saying she had hurt him. And he's saying, no, she just did this to me. And the police are there. They took record of it. And he was able to get a restraining order. And she was prohibited from having contact with the children because of this. And, it, you know, it was tragic. You know, it was very sad situation for this woman that she found herself in. And, you know, that's why we can't do anything with that in mediation and it needs to be litigated. But I do think that people don't even understand when they're in those moments about how they're communicating what's happening, right? Because they can create more problems for themselves.
Correct. I like that example that you just gave because people don't realize that honesty can hurt you.
Right.
And it's one thing to be honest, and everyone should be honest. But when you're talking to law enforcement, you need to be mindful that what you say will be used against you.
Right.
And you need to be cognizant of that fact, and you have to assume the worst, as in what happened in that situation.
Yeah, I should point out that too, and what was kind of frustrating here was there was a language barrier and a cultural barrier for this individual. And so when asked a direct question, she gave a direct and honest answer, not understanding context and everything else that can come into certain situations, and understanding that any statements, as you just said, would be used against her as evidence in any hearing moving forward. And it's unfortunate because, again, in the emotion of a situation, with anxiety, with frustration, with fear, we communicate very differently, right? And we logically think through all the steps and explain the story in a certain way that helps provide full context for things.
Correct. And in the example that you gave, like if the children are there when the incident arises, that gives you the ability to name the children then as protected parties, which is probably what this father did.
Yeah.
And then prevented mom from seeing her kids because this incident maybe took place in front of the children.
Right.
And courts are more likely to include the children as protected parties when they were present during the incident.
Right. So one thing that, as we're talking right now about this, that I think that I would like to express to anybody that's out there that might come across this, is that I always say to people, if you feel that you're in a situation like this, not particularly this circumstance, but you need a restraining order or you are on the receiving end of a restraining order, don't do this alone. Like, that's why people like you are here, right? That's why you have this specialization. That's why you're a certified family law attorney, because I've seen it too many times where people go in and, okay, so you've been practicing law for 20 years. Take me back, right? Take me back to the first month of practice, or maybe the first month where you had to go into court, right? You'd been through law school, right? You'd interned, you'd externed, you'd clerked, all that kind of good stuff. Now you're going in and you have to stand in front of a judge and present evidence and argue a case. Were you the most stellar, confident, competent, amazing individual ever?
Oh gosh, I still remember on my drive to my first hearings, repeating in my head, "Good morning, Your Honor. Swati Desai for the petitioner and moving party. Who is present?" And I just said that over and over again so I wouldn't screw that up.
Right.
You don't know what you're doing. You don't get that training, right?
Right.
It's a skill set that you develop over time on how to effectively present evidence,
right,
what evidence you should present,
right,
and why, because you don't want to waste the judge's time.
Mm-hmm.
And, judges know when attorneys are prepared, and judges know whether or not you're wasting their time. And if you've given the court an estimate, that's another problem. Our courts already didn't have enough time before the pandemic.
Right.
Now they've got like really minimal time and very little patience.
Right.
So if you're going to present evidence, one, you need to skimp it down to maybe just a few pieces. We're actually capped in Orange County as to how many exhibits we can attach to our documents. And some judges do have some leeway, but we have to really be strategic on what we're using. And don't be the person that says, well, I've got, 4 witnesses and I've got, all this evidence. Well, you have to call them all. Well, let me talk to your witnesses and let me see what they have to say. Because if 2 of them are going to testify to the same set of facts that they observed, we don't need both of them. Right. It's duplicative. We just need one.
Right.
And if maybe one is more helpful than the other in the interest of time, you're going to get a court date sooner if your time estimate is shorter.
Right.
And that's motivation to shorten the amount of court time you need.
Right.
So sometimes the clients will then hear the judge say, okay, you guys can come back April.
Mm-hmm.
Okay, April of 2021. Yes, I told you that's called the pandemic.
Yeah.
The delay.
Right.
And so, then they say, okay, well, can we shorten the amount of time?
Right.
Yeah, we can.
Yeah.
We can't call so-and-so as a witness or so-and-so. You can introduce maybe 3 pieces of, 3 exhibits into evidence. Are you willing to do that? Yes, I'm okay with that. I just want this done and over with sooner.
Right.
And then I tell the court, okay, my time estimate is no longer 3 hours.
Mm-hmm.
It's 45 minutes.
Yeah.
Or it's 1 hour.
Right.
Okay, then we can squeeze you in about 2 months, right? It's more
Right.
palatable for clients to stomach that. So
Right. And I think people don't, fully understand that all of these, circumstances that they encounter and engage when they get into court, right? Because we see a lot of wonderful legal shows, right? Where people get up there and they go in and they talk in front of the judge. And in reality, that's not the way it works. As you said, the judge has so many cases to get through in a day. They've got so much experience in this. They know what they need to get out of this. And if you're going in there trying to present your case for yourself, there's every possibility that you're going to freeze up, that you're going to feel confused, that you're not going to understand. Yeah, I've seen it too many times where somebody gets in there and they get tongue-tied, right? And they are unable to explain clearly what's going on. And that then frustrates the judge and doesn't help their case, right? And it's very sad and very tragic. And I've seen where people were on the receiving end of a restraining order, and they, when you really looked at the facts and circumstances, there wasn't much there, but they decided that they would go in unrepresented and, present their case. And in the moment against an attorney on the other side, then they lose. And so when somebody comes to me and they say, look, this is going on, I'm like, get an attorney, go speak to a professional. This is what they do. This is why they went to years of law school and they have 20 years of experience, because they know exactly how to speak the language of the court, how to communicate effectively with the court, to help them understand what's happening here in your particular case and with your circumstances. And so I advise against doing anything, especially when it comes to your children, right? So if you're talking about, as we've already touched on, substance abuse, alcohol abuse, whatever it might be, going in and trying to present either a need for, testing, whatever it might be, or to prevent yourself from having limited time with your kids. And then anything with the restraining order, get an attorney. Have somebody on your side who knows the language of the court and who can help you effectively communicate what's going on here.
So I have a question for you regarding the domestic violence situation. I mean, you guys do magic with your cases. So when you have two parties that have had a history of maybe domestic violence, how do you tackle that subject when it comes up?
So generally, where there has been a restraining order in place, we won't mediate. Because what it does is it creates a power imbalance, right? So what you have is, in any mediation where one person feels in fear of somebody else, it's very difficult to mediate that because of that power imbalance. Because what you've got is you've got two people at the table. And if I don't say what the other person wants to hear, if I don't agree the way they want to agree, then I'm afraid what's going to happen outside of this mediation. Right now, I'm sitting here with this nice mediator who's very professional and knows what they're doing and can help us kind of come up with an agreement. But if the one person says certain things and I disagree or I contradict that, whatever it might be, I fear for the ramifications. So that's something as mediators we have to be aware of. We can't effectively mediate when one person, for example, when I mediated restraining order cases, civil harassment restraining order cases for the court, we kept the parties separate because you weren't sitting there looking at this person who had threatened you or who had threatened to expose information about you. They weren't, it's interesting because we would take the parties out into the hallway, from the courtroom out into the hallway, and stand there to call their cases, to send them off with mediators, and we'd take them separately. But every once in a while you'd have somebody kind of go, they're threatening me, or they're giving me the evil eye, they're taking photographs of me, and immediately, because the tension is there. So it's impossible to put two people like that into a mediation. And that where you go to domestic violence, where it is that kind of a relationship, somebody can come across as the most wonderful, civil, polite person in society, right? Out in professional circumstances. But in reality, there's a lot more going on in that relationship. So where we are aware, where somebody has advised us that there is domestic violence, where there is a restraining order in place, we do handle high conflict situations. I've had couples that come in where, and people think, oh, we're going to go to mediator, we have to be kumbaya. We already have to be at the point where we're like, I love you and you love me. And we want to uncouple, consciously uncouple like Gwyneth did, right? So let's consciously uncouple. most of my folks that I work with, I have them sitting here and they, not most of them, but quite a few hate each other. They're very angry. It's just a very sad situation. So that's not what we do. We don't deal with the pretty situations all the time, but we are cognizant of that power imbalance that comes into play with domestic violence. And so it's better in situations like that the parties go through an attorney and feel that somebody's advocating for them. And maybe what they need to do is include, as you said, some kind of stay away agreement, right? As part of, because they can settle between themselves with the help and assistance of an attorney, but they've got a Swati Desai advocating for them, right? So they're able to come into your office and say, look, these are some of the problems that I've encountered. So you're not intimidated by the other side. You're not fearful of the other side. And you know what you need to do to protect your client and put kind of parameters in that prevent any problems moving forward, right? So in mediation, we're just aware that because they do come in here unrepresented, that can create, a power imbalance, as I've said, in the mediation, and can skew the results because somebody they'll agree more readily to certain things to avoid the conflict, to avoid ongoing harassment.
Got it. That's a good point you make about the power imbalance, because it's I see it when we don't get a restraining order, but there's been a history of domestic violence, and the client says, no, I don't want to get a restraining order. I just want to be divorced.
Right.
We don't live together. I don't feel scared for my safety. Okay, that's fine. But then when it comes to discussing the case, I could just see them kind of like, I don't know what to say to him. I don't know. Well, you don't need to communicate with him. When he talks to you about the case, just say, I thought you have your lawyer, I have mine, and let's just have all communication take place through them. And then when they open the door just a little and they start discussing the case, well, guess what? Now they want to open the door wider. The other party does. So I tell them, you just got to keep that door shut.
Right.
And the minute you start talking about your case, they're going to think they can take advantage of you because they did before.
Right.
And let me be the bad person. Let them just say, why can't we agree on this? Why
right.
Just say, my attorney isn't letting me. Then you can blame it on me rather than taking the heat for it.
Right. I mean, I've mediated high conflict situations where you can tell that there is a power imbalance that exists. And so in those moments, what I'll do is I'll separate the parties into two different rooms. So where I'm cognizant of the fact that maybe one of the two is agreeing too readily to things, or, one is being perhaps a little assertive and aggressive in their tone, more than, and putting it in context, I've been doing this for a very long time. I can read when people are angry and frustrated with each other. And I think conflict is not a bad thing in mediation. People raise their voices, they get frustrated. We need to understand them, work through those feelings. But when you key in and you can see that dynamic happening, what I'll do is I'll separate them into different rooms so then I can have an open and honest conversation. And then they'll talk more freely with me. And so they'll kind of say, look, this is kind of what's going on, and this is what I'd like to have happen. How do you think we can work through this? And then I can do what we call shuttle diplomacy, working back and forth between the parties in two different rooms to help them reach a resolution. And then what I get to do is I get to be the bad person in the room and say, look, you know what? I'm going to test you on this, and I'm going to play devil's advocate, right? So it's not the other person. It's not the other person in the relationship. I get to take that role on. And it's not that I'm advocating for one over the other. I remain completely neutral. But what I'm trying to do is create a little bit more balance. So by splitting them into rooms, the one person feels much more comfortable talking openly about what's happening or what their goals are for the mediation. So those are just some things that we use because we don't get them coming in every day holding hands and kind of be, consciously uncoupled. Sorry, I use that phrase because it just makes me laugh, right? Because it's a very difficult thing to do, is to work through this. It's a very emotional process. Whether they're doing it in mediation or they're doing it with the assistance of an attorney, it's a very difficult process. It's a very emotional process. And, I think that I always say to people, you have to do what's best for you in your circumstances. There's no two situations that are identical, right? We hear very similar stories time and time again, but the parties to the stories are very unique and individual.
Mm-hmm. Yeah, I agree. And I love hearing about, I think what you do is so hard because you have to find a balance with both of your clients.
Mm-hmm.
And it takes a very special personality type to handle those high conflict situations and to come up with creative solutions on how to, kind of bridge that gap between the two of them.
Yeah. I mean, for me, I think doing mediations for the court, doing restraining order cases for the court for as many years as I did, that really helped me develop my skill base because, as a mediator, you can't allow yourself to get offended by what people say because sometimes people lash out at me, right? So they turn their frustrations on me. And I'm not offended by any of it, right? Because I can't take it personally. I remember talking to a friend of mine when I lived in London a million years ago, and she was a social worker, and she talked about some of the situations that she had to come into, care in the community situations, walking in and dealing with people in horrific situations. And I sat there and I thought to myself, how do you deal with that? How do you handle just those really sad, tragic situations that you deal with on a day-to-day basis? And, for you and I in this world, it could be the same thing, right? And part of our job is to learn how to help people without taking on their emotional burdens, right? Because that's a difficult thing. Because if we took on all of the clients that came in, all of their emotional burdens, there'd be nothing left for us to give. Because you've got kids, I've got kids, and heaven knows when we get home, they're ready to throw physical and emotional things at us, right, on a regular basis. So, you have to learn how to work through that. And it's an interesting thing to do as a mediator because I love what I do. I love my job. I love working with my clients. I love helping them. For me, the thing is seeing that at the end, seeing that kind of bringing them to that point where they come in like this and bringing them to the point where they are able to work together and come up with a resolution, especially when there's things like children involved. Because I say to people all the time, your kid is 5, 10, 12, whatever. I'm 48 years old and I call my mother in Ireland every week and chat with her, right? And she can't get rid of me and my problems, right? And so we're in our kids' lives forever. And so that means if we're divorcing, the other person's in our kids' lives forever. And so we have to figure out a way to exist in the same world and not create a situation. And I have clients, I have one woman that I'm working with, one couple that I'm working with right now. She told me her parents divorced, a million years ago. But when one parent comes into town, it becomes now it's my time. You don't see the other parent, even though she's in her 40s, she's an adult. But there's still this tension between now you're mine and not the others. And that's unfortunate because that puts a lot of burden on the child. Even as an adult, they feel that burden.
That's so sad.
It's amazing. It's amazing what people do, right? In divorce
Yeah.
situations. And that's why I always say is work with a good professional, because part of what you do for your clients is you help them to work through. You're not just their attorney, right? You have emotional intelligence. You're helping them work through some of the issues that they're dealing with, or you're at least pointing them in the right direction. And I do that too, where I'm like, I sense something's going on. I'm like, do you have a counselor? Do you have a therapist that you can work with? Let me recommend somebody, because they need to be able to work through these feelings and emotions to be a healthier individual, a healthier parent, a healthier member of society, whatever it might they might need to be. But your ability to connect with them and read them the way you do because of your emotional intelligence makes a difference in your role as an attorney, because too many people see it as this is my job and my job is to get you from point A to point Z, right? But you're seeing everything that goes on in between that, reading and helping them and guiding them through the process, which I love.
And there's a different level of, you can go see 3 doctors and they'll give you 3 different opinions.
Right.
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 It's the same with lawyers. You could go see 3 different lawyers, and they're going to give you 3 different, strategy protocols as to how your case should be handled. And what I always tell my client is, really, you're in the driver's seat, and you get to decide where we're turning this case. And if you want to be litigious, this is what we would do. If you want to be a little litigious, but not overly litigious, this is what we need to do.
Right.
If you want to just get a divorce and you want to do what's necessary to just get divorced, then this is what we're going to do. And every single client, usually by the end of the consultation, understands the benefits and the disadvantages of going through option 1, 2, or 3.
Right.
And that's why I don't like to cookie cutter every case, because every single client has a different need. And I've had clients who've come to me and they say, look, I'm represented, but I'm just not happy with my representation. I'll review the documents. I said, well, I think you're getting good counsel. I think you're being represented really well. What are you unhappy with? Well, I don't understand why my attorney keeps telling me that, I can't get that the other party's going to get 50-50.
Right.
I said, okay, well, why do you think they shouldn't? And then I make them do the work. I make them explain to me why the other parent shouldn't have 50-50. And then I ask them, well, did you tell this to your attorney? I did. And they just said no. Said, okay, well, then you probably need to change lawyers.
Yeah.
Because I think you have a good fact pattern.
Right.
And I think you need to file an RFO sooner rather than later, so that you put your position before the court before the other side does, and you're just now responding to their request. And if you've been giving them, a significant amount of time since separation, it's going to be used against you. Oh, I didn't know that. So it's about how aggressive the attorney wants to be. And you probably at the time you hired your lawyer, what did you tell them? That I didn't want it to be nasty. Okay, well then, you have to realize the attorney's trying to follow your expectations. So when you ask them questions, they're keeping that in mind. And now maybe your expectations have changed, but you haven't maybe you haven't communicated that properly to the attorney. So, I just tell all of my clients that you need to tell us where you want this car to go. And it's going to go in the direction that you want it to go. But we're going to ask you some tough questions before we do that, because I don't like using your money to get you a result that I knew, was inevitable. Like, if you want a result, it's going to cost you.
Yeah.
But you've got a really good chance of getting a really favorable outcome.
Right. Yeah. I mean, it's interesting, right? Because in my field, in mediation, I have people, when I meet with people for a consult, one of the last things I say to them is, look, you're interviewing me right now. So part of what's going on in this consultation is you're saying, is David the right mediator for this case? Is he the right level of, professional, emotional? Because, some people want a little bit more of the emotional. Some people want just down to business. What do I address that for you? And if not, go out and meet with other mediators, find the right mediator that fits the facts and circumstances of your case and what you're looking to get out of the mediation. But it's funny because I was saying it to Amanda and Jen recently. I've had a couple of people come in and I'll talk to them and they'll say, well, you seem competent. And I'm like, thank you. It's like, who are you meeting with? And, somebody said to me the other day, well, I talked to this mediator and they said that this was based on how long we've been married. This is how long I'd pay spousal support. And I went, well, that's wrong. And I said, and they probably misheard you and whatever else. I said, but I don't want you to be confused. You're actually a long-term marriage. So this is what it would look like, not half the length of the marriage it would be. And this guy said to me, he said, well, that's what I thought, but I was really confused. And I said, well, maybe that's not the right mediator for you then. But it's funny because I think that what we also have to understand is that there are a lot of people in both of our communities, right? A huge range. And they also run the gamut from, you know, brand new or sometimes not willing to understand or put in the time and whatever else, all the way through to my heroes, right? On the other end of the spectrum. And I have no doubt it's the same for you. And so it's really, I say to people, find the right person that fits what you want. Because people will call me and say, you know, tell me all about what you do. And I tell them and they say, well, how much does it cost? And I'll tell them. And then they're like, well, that's too expensive. And I'm like, great. So there's probably somebody out there that works within your budget. So that's something that you need to find, right? And so, you know, there are people who work within everybody's budgets. And so, and they'll work within the emotional range, the professional range, whatever it might be. But I think you bring up a very good point, and I see that like I'm out of time, but you bring up a very good point, which is the more that they can tell us and the more they can help us to understand about what they want to get out of this process, that makes a difference in what we can do for them, because we can't read their minds, right? There's only so much that we can understand about how we can help them. If they want something different, they need to express that clearly, and then we can figure out if we're the right person to give that to them.
Correct.
Yeah. Awesome. Well, Swati, it's like that hour went fast, right? I mean,
it went super fast.
This is what I said. I like every time I talk about doing this with you, I'm like, I'm not even going to think about it, because we're going to sit down and start chatting. And I love talking to you because you know your stuff, and it's fun to learn from you. It's fun to talk with you. And I do appreciate your willingness to give your time today so that anybody who's watching this can learn about what you do and learn about preparing for court and what that process might look like. So thank you so much for your time today.
Oh, it's my pleasure. My pleasure. Thank you for having me.
Yeah, it's been fun. All right, I will talk to you soon. Check out Swati. So what we're going to do is we will be posting this, I believe, and we will post a link to Swati's website for her law firm, the Desai Family Law Firm. And so you can go and if you have questions, you can reach out to her and her partners and her associates directly and talk to them. And if you need anything or if you can't find that connection, definitely reach out to me and I will put you in contact with Swati. So Swati, thank you for your time. Have a nice day and I will talk to you soon.
You too.
Take care. Bye.